Welcome, everybody. This is a properly convened meeting of the hearings panel called for the purpose of hearing a resource consent for the application for a subdivision consent at Bedford Road in Cromwell. I'd ask the Minute Secretary to report on the proceedings to date.
All statutory requirements under Section 95 of the Resource Management Act have been complied with. The Section 42A report by the Planning Officer has been circulated to address for service.
Thank you. The following procedure will be followed for the hearing. The panel may ask questions. Council officers or its consultants will direct any questions or points of clarification through the chair, and the chair shall be deemed to be the person asking the questions. The applicant or the applicant's representative will be invited to make submissions and present evidence, which no applicant is here today. The 42A report writer will then be invited to provide a right of reply following hearing of evidence. No submissions today. The applicant will have the right of reply, but shall not be permitted to again traverse the evidence or raise any new evidence. Before proceeding with the hearing, I would ask that all parties identify themselves. I am Tracy Patterson, Chair of the committee. Martin McPherson and Sarah Brown, both commissioners here. And we have Jessie, who is our Minute Secretary for today, and Rogers and Tim Anderson.
Fantastic. Hi guys, I'm Maddie Albertson from Patterson's representing the applicant. He sends his apologies for not being in attendance today.
Okay, thank you. Right, okay, so I'm going to ask that to motion that the Section 42A report be accepted and approved. Thank you, Martin. Seconded Sarah. Those in favour, aye. Against, carried. Thank you. Procedural matters, just for myself, Jared Brentsell is known to me. He was my daughter's rowing coach, but I don't believe that is enough to warrant any significant issue. Anybody else?
The applicant is known to me. My many children, his children are at school with mine, so we're all parents only, and again, no conflict.
Okay.
I don't know.
Okay. Right. So, Maddie, over to you.
Okay, well, thank you very much, everyone, for being here today. This application, in short terms, is just seeking to rearrange 3 existing records of title and change boundaries between those. It did not qualify as a boundary adjustment, so we have applied under the subdivision rule, CODC. Because one of the titles was already under the 2 hectare minimum, it triggered a non-complying status for the subdivision. But in actuality, this is a rearrangement of 3 productive used titles that are currently in operation with an orchard. The applicant is looking to do some improvements on the orchard and some expansion of the orchard, and would like to rearrange the titles to better facilitate the use of the land. More specifically, better facilitate access to the existing water race going through all the titles. So we're here today in the hopes that we can find a common ground or a solution to make that happen.
Okay, thank you. Questions of my panelists?
Maddie, talk me through your reasons for objecting to some of the conditions regarding the water to lot 3.
Absolutely. So effectively what we've applied for is to keep the status quo of what is happening on the land currently. So in current form, I'll get my thing out so I can make sure I refer to the right lot numbers. So existing lot 2 DP 44713 is fully serviced. It has domestic water and it has power. The existing orchard block, which is on lot 2, DP 541460, that has power. Oh, sorry, no, that has water, no power. It doesn't have electricity needs at this point. But lot 1, is proposed to stay as it is, which is currently unserviced. There's no indication at this stage that any of the rural productive permitted activities being undertaken on that lot are going to require services. And if they do, there is the ability for them to connect in the future if they wish to. But our request is just to keep it at the status quo as it is currently to enable the titles to be rearranged. Oh, and apologies, Martin McPherson. The other objection in terms of the condition requiring water rights for irrigation to be given to all of the allotments, that is specifically due to the overlap with the regional council in the instance of irrigation water. So the Burn Cottage Road catchment is part of the Burn Cottage Road irrigation scheme. This scheme has been issued a water take and irrigation consent by the Regional Council, which has its own requirements for the scheme to operate under. And how that operates is if you are within the catchment, you can approach the Burn Cottage irrigation scheme to enter into a water supply agreement. And that is a separate legal process. And the irrigation scheme itself ensures that it is meeting the requirements of the regional council. So anything in that water supply agreement is directly ensuring that they are not contradicting or going against any of the conditions of their irrigation consent. So the risk of imposing through a district council consent conditions to supply irrigation water is that it could actually go against the regional council consent. Regional council water take consents are not indefinite. They do lapse eventually, and there's no guarantee that they will get water after it expires in 2044. So the reality is the legal mechanism is there for any future lot owners to apply to get water through the irrigation scheme, because they will also be paying their share as part of the water scheme, and they will need to have an understanding of what they're irrigating on the ground compared to how much water they need versus how many shares they buy as part of that irrigation scheme. All of the lots are within the catchment area, so they are fully within their rights to apply to get irrigation from the scheme, and they have fantastic access given that the race goes through all the allotments. But the risk is being that the subdivision and any imposition of consent notices stay in effect in perpetuity, is that it could directly contravene any future regional council consents or the existing one.
Somebody want to address your comments later on this morning.
Just, can I just pick up, I just want, while we're picking up on that water, that was one of my questions, whether they had a water services agreement. So would it be unusual, do you think, that a piece of land would have no access to irrigation water,
No,
given that it's in a rural?
I would not. So there is an existing water supply agreement here, and there are shares available, and there is a legal mechanism already in place to enable that everybody can have access to water. What will not make it easier is having conditions of consent that have additional requirements, because the reality is there is 5 years for the subdivision to be implemented if it is given effect to. The irrigation scene might change, the permitted rural productive use of the land might change, the needs for irrigation might change, and forcing any future owner to have to buy water that they may not want or need for an activity that they haven't decided, I don't believe is a good way to ensure that there is access when it is there currently. But it might not be after 2044.
A water supply agreement usually has a quota
Yes,
attached to it. So at the moment, are you saying that there is no quota attached to that property?
there is a quota attached to the property for the current ongoing irrigation of the orchard, and that will stay. And there is still many shares available in the Burn Cottage irrigation scheme should somebody want to join in the future. It is not at maximum allocation, but the overall irrigation of the land especially when considered under ORC, it needs to be directly attached to what they are irrigating. So that is up for the irrigation scheme and the shareholders of the water supply agreements to decide what is appropriate.
So they, in the letter here from the chair, Mr. Webb, it says that there's 2 hectares of land, water and burn cottage, and this is, they're proposing to subdivide. In exchange for the existing, the separate hill title will be entitled to irrigate water supplied by the burn cottage and by the irrigation company. So that there has been, and correct me if I'm wrong here, if I've misunderstood, is that something completely separate to what? Because this looks like it's an exchange for something else. What I'm trying to get at is I really need to, I mean,
You
for
want
us to consent to something without water, despite what you say about the OIC, I'm just trying to understand how this is.
For sure. So the nature of the scheme, excuse my colloquial terms, it's pretty old school. It is directly pumped from Lake Dunstan in a pump house down by the lake. It is then pumped uphill and fed through a manual race. So the organisation of the irrigation scheme and all the shareholders in it is very informal. Because it is a physical race organisation, they do all have to work together in terms of how they manage and use their water. So if somebody wants to send water down the race, everybody is knowledgeable about it. If somebody's filling their dam or they might have overflow, they're in constant communication. The reality is this is not a piped supply. This is not an on-demand supply. This is an old school irrigation scheme where if you have supplied a water, you have to negotiate with your neighbours and the scheme about when and how much of that you have access to, and then how it is used on your land is separately managed by the legal portion of the water supply agreements. So I think we've got to separate the situation here with the irrigation water and the domestic water separately. Lot 3 and Lot 2 have domestic water. Lot 1 has the ability to get domestic water if necessary, and all 3 lots have access to irrigation water. Obviously, the orchard will stay irrigated, and there are plans. The applicant has plans to construct a dam to further. He wants to secure water irrigation for the long term for his orchard so that he doesn't have to risk that negotiation all the time, anytime he wants to for his orchard. But the reality is he doesn't know what the future might be for Lot 2 or Lot 1, how many trees will be there, how much water will be there. So there needs to be flexibility to ensure the shares of that water supply agreement are appropriate when it's decided what's happening on the land. And when it is decided, they have the full ability to get those shares.
So I guess I still coming back to, I'm just trying to figure out how we actually feel confident. It's maybe something that Mr. Anderson brings in, but just how we actually feel confident that a piece of land that is designated, is proposed to have no irrigation quota. I guess I just need to have some reassurance that we're going to be able to have there's going to be no.
I don't think it's
so we haven't been provided a copy of the water supply agreement, so we don't understand where that is. We don't know where. I accept that you've said they've got the there's a informal agreement. But I'm just, it's a.
So I have, with the evidence submitted, the regional council consent for their irrigation scheme, which does prove it is not what we're proposing is no irrigation water. I would dispute that as being factual. The site is within the consented catchment. They have legal access to this irrigation water. They can approach the scheme and will be granted shares. Those are available. So they can access it. It's just that conditioning it through a subdivision consent is not going to make that supply any more guaranteed, especially after the year 2044, should that consent lapse. So it is available.
So in relation, we'll just move on to the domestic water. Is that provided through is the domestic water part of the irrigation scheme, or is it a completely separate scheme?
Separate scheme. That is the Burn Cottage domestic water.
Yeah, I saw that on one of the planning maps, and I just want to get that.
Yes.
Okay, and just, where does the domestic water, is that is a completely separate supply?
Yes,
altogether?
yes.
Okay.
And I think one thing I really wanted to highlight is the need for, when we're talking about water, the separation, talking about rural irrigation supply, which is traditionally handled by the regional council, versus domestic supply, which is managed and handled by the district council. So there are many provisions and rules and regulations under the regional council to be considered when looking at rural water and rural water supplies and consents.
So Burn Cottages is managed by council.
I believe it is a
domestic supply
community scheme. I'm not entirely sure what the management is on the community scheme. Yeah.
Okay. Sorry, with water, anything further, especially in relation to water?
And you've just covered quite a bit of it. No, that's good with it.
Okay, any further questions? Not related to water or anything else? All right, I've got a question in relation to the alluvial fan. In the original application, was there any geotechnical information that, you know,
No.
so nothing in the original?
There was none.
Okay. No. Because I note that all right, I'll just go to the letter from Mr. Brensel.
Yes, the alluvial
He's not.
Yes.
He's not a geotechnical expert, is he?
No, he's not.
Okay. And what was your reasoning for not requesting accepting our request to do that?
Absolutely. So the reality is this application is for a rearrangement of 3 existing titles. We are not proposing any structures. We did actually approach many qualified experts to try seek their thoughts on getting a geotech assessment against this alluvial fan, and they provided us with a few comments. One being that the ORC mapping is very broad and generalised. It doesn't mean that the risk is lessened. It's just that the mapping is not site specific, it is regionally specific. Further to that, they stated, the second question was, well, what structures are you proposing on the land for us to assess the risk against? And we said, well, there are no structures proposed. And we understand that it's a non-complying activity to propose any structures in an alluvial fan. And they said, well, it's very hard for us to assess a regional scale risk when you don't have any proposed structures. There's no design or foundations or anything proposed for us to assess against. So all we can say is that regional mapping exists and that it would be more appropriate for it to be assessed in the future should any structures be proposed on the site.
The proposed structural trigger the hearing.
Non-compliant consent.
It's a non-compliant activity.
And there was something else that I had in here, just bear with me. The reverse sensitivity. I note that and correct me if I'm wrong here, I note that there was you request to get rid of the consent conditions from the original subdivision in relation to reverse sensitivity due to the rearrangement. But I couldn't ascertain, I understand the mapping from the fan on the applicant's site, but is there any other fans that are on neighbouring properties that would be with the location of those sites that could cause an issue?
Oh, sorry, apologies. Are we talking about frost fans?
Frost fans.
Sorry, not the alluvial fan.
No, sorry, no, so yeah, talk about reverse sensitivity.
Right, of course. My understanding was the original conditions relating to reverse sensitivity was when there was the consent available for a dwelling to be constructed on the underlying lot 1 DP 54146I. As this block is now going to be absorbed into proposed lot 3 with the orchard, there is not going to be a dwelling on it. The original reverse sensitivity conditions were in case there was to be down the line a dwelling built on lot 1. The reality is that dwelling is not going to go ahead. That will be part of the orchard. So we are proposing to remove any of those redundant conditions. I am where the applicant is completely happy to accept a condition of reverse sensitivity if the panel believes that it would be a better solution for the surrounding properties. But my understanding was its original imposition was when there was going to be a dwelling on one of the sites, which there is now not.
In relation to the right of way, just when I look at the map, as in online and also what's proposed, it's a slightly different variation from what looks like on the property boundaries. So how does that, can you explain that through?
I can.
Is that a whole construction of a new one, or can you explain that?
Yes, yeah. So effectively at the moment, as the whole site is in orchard in rural, there is not any residents living there. The orchard block is managed and accessed informally through neighbouring properties. You can see on the GIS that there is a lot of neighbouring orchards. So when the applicant is getting the workers to come to sites to prune, pick, maintain, net his orchard, they're actually accessing informally through neighbouring blocks that they are managing at the same time. They're co-managing them. So what we've proposed in the subdivision is to fully formalise the access into the lots, with lot 3 having a new right of way that will be formed to council standard.
Okay, right. And we'll now turn over to Mr. Anson to the section 42A. And just one else.
Okay, I'll just note that I was not the author of the section 95 and came into this a little bit late in the piece. However, I do agree with the outcome of the notification determination and Mr. Vincent's recommendation that it be processed non-notified. I do agree with the applicant that this is largely a reconfiguration of existing allotments, and it not result in any significant or notable change to receiving environment. The proposed allotment will not introduce any additional domestication and will largely maintain the productive use of the sites. No notable change to servicing and the existing productive uses. Acknowledge from the evidence there was an incorrect reference in my 42A report to lot 2 DP 54146. This is on page 2 under the site description. In terms of domestic servicing, First, I accept what Salverson says about lot one. It is a rural productive lot, and it's intended to remain as such. Therefore, the recommended change to condition 9 in terms of power would be appropriate, and so the in terms of the potable water condition, condition 5. As far as the removal of condition 6 goes, whilst the applicant puts a case that the water is available, it does leave uncertainty without that guaranteed supply. Not sure if perhaps the documentation that's been provided so far as it provides enough assurance that can be maintained in the future. If the panel is happy with that, then be agreeable to the removal of that condition as well. In terms of the alluvial fan, it was, as discussed, several requests made for geotechnical evidence, and whilst I can accept it, there's no additional buildings proposed and no additional residential units. There would be a necessity, I feel, for at some point geotechnical assessment to be undertaken on any future building platforms. There does exist within each proposed allotment elevated areas where buildings and potentially dwellings could be constructed where they're at an elevation above the flood risk. However, in the absence of proposed building platforms, there's still a degree of uncertainty. That would be my preference, just for clarity, if there was additional certainty provided on that. But overall, I stand by my recommendation that effects can be appropriately mitigated through conditions. That recommend that the decision be granted by the panel.
Thank you. Any questions of Mr. Anderson?
Tim, summing up, you're quite happy with the amendments as proposed by the applicant?
I think with in terms of the domestic servicing, there aren't any residential activities proposed, and it's further covered by the consent notice under condition 12 that brings the attention that the lots are unserviced and not intending to be serviced. In terms of the irrigation water, I do accept Ms. Albertson says in terms of what the current arrangement is. But potentially for comfort, maybe that condition could be reworded so that rather than directly being provided, that irrigation water can be properly assessed or supply somehow guaranteed in the future. I'm not sure exactly what wording would be appropriate there.
And the applicant may want to address that in her right of reply.
But everything else within the scope of this, the alluvial funds are relevant if there's no building plan largely to those things have been things that we were unsure. Everything else isn't.
So,
I think
I guess from the alluvial fan in relation to the question that I have is, would it be a condition of consent that we would have that if any residential activity was to occur, a further geotech report would be required, and obviously a building platform? Is that where we were heading in relation to that?
Yes, that could be included as on the consent notice.
And I guess the big thing is that the reduction in size to lot one, while I acknowledge what you've mentioned before, I just guess what assurances the panel have in the absence of any solid information in relation to supply of water for irrigation purposes. We also that's something that's sticking with me. So as you can tell, so I guess the panel needs to know what assurance we're going to have. So the rewording of a condition may be appropriate. I'm not sure. Absolutely discuss that again, but it is something that I think needs to be further. So I guess I still don't understand your rationale for coming to that decision. I don't know whether it's I'm labouring the point, but the irrigation for a small lot, which is still within the rural, and is presumed to be have a rural activity. Yeah. I don't know if you've got any further comments on that. Just trying to. I guess it's in the absence of the information. You're saying in absence of information, you're happy with that as it stands.
I would support further information and clarification for condition 6 to be removed or a suitable rewording to ensure that there is a guarantee of supply.
Okay. Right. Thank you. Okay. Soutson, it's your right of reply. You can take a moment if you need to, or if you're ready, we're happy to proceed.
Quite happy to speak further on those couple points. I think I'll start with water, as it seems to be the sticking point, specifically irrigation. I don't know how much clearer we're able to make this. When you approach the regional council for an irrigation take, there are several areas of information that you're asked to provide. Specifically, what crop is it? How much water do you need for that crop? Have you previously had that crop on your land? What length and rate of water are you seeking to put on that crop? The reality of regional consenting is that many of our catchments are significantly over allocated. So they are very, very strict on how long your consent term is for. You are not guaranteed irrigation water in perpetuity ever. There will always be some semblance of uncertainty. What we don't have uncertainty over in this instance is access to that water. Burn Cottage Irrigation Scheme includes the site. They have consent for irrigation water. The applicant and the future allotments will have access to that water. All they have to do is to enter into the water supply agreement. The reason why condition 6 was proposed to be removed from the conditions of consent is because it's requiring connections. This is a water race. There are no connections. People could put a board and flood irrigate their land if they chose to do. And it really just depends on what is decided to be grown or produced on the site. It is up to that future owner or the current owner to decide what is appropriate, and how they choose to connect into that race or use that water does need to be consistent with not only the regional council consent, but also the water supply agreements that govern how that water is used. It is not going to give any further certainty by putting a condition on here requiring connections to the race. It is not something that has been historically done in CODC. It is traditionally left to the regional council. This is not a piped or physically provided water scheme. It is a water race that is turned on and off depending on the need of everyone within the scheme. We would be open to agreeing to supplying a copy of the water supply agreement at 224, but there's no guarantee that that water supply agreement will outline shares for all of the allotments, because until they decide how exactly they're going to grow and what they're going to grow on those allotments, they don't know how much water they're going to need. So forcing them to buy water shares without having any idea about what's going on those allotments is unreasonable. So I'm open to some kind of rewording so that council is provided the information about the water supply agreements. We can do that. I just do not believe it would be appropriate to force future landowners into owning an amount of water that they don't know how they're going to use. And that could directly contravene the regional council consent conditions for irrigation. So that would be my point on the irrigation water. And I'll move on to the geotech situation and the mention of uncertainty in that. I note questions about including a consent notice about requiring a future geotech report. We would be open to agreeing to that, with the knowledge that approaching council to put any structure, be it a rural farm shed, be it a dwelling, be it any structure, be it a deck over 1 metre high, in that alluvial fan would be a non-complying activity, and we would be sitting here in front of you again. And it would be completely reasonable if a structure was proposed to request a geotech assessment against the design of that structure in the alluvial fan. I do not believe in this instance nominating building platforms is appropriate. We're not proposing structures. So a consent notice we could be open to including, just to bring to people's awareness that it isn't an alluvial fan. If they did want to construct anything within the alluvial fan, they will need a geotech report to accompany their application for resource consent. But I do not believe for what is proposed, which is essentially a rearrangement of existing titles, that requiring the nomination of build platforms and a geotech report at this point is necessary. There is not uncertainty for the risk. There are trees on the site. I think that's all.
Okay, so the decision of the hearings panel is reserved. The formal decision will be in writing and will be available within the statutory period of 15 working days. In the event that the release of the decision is delayed, the applicant will be advised of the delay.